During the government's initial argument, make sure that you are taking notes as to any key points that you want to counter during your argument. If you're thoroughly prepared, there really should be no surprises, but just to be sure, make sure that anything that they bring up that is damaging to your defense, that you take notes on that and make sure you're prepared to address it. It's also important to listen carefully and to object to any improper arguments made by the prosecutor. In my experience, unfortunately, prosecutors oftentimes overstep and make arguments that are inappropriate, overly prejudicial, and therefore objectionable. Although appellate courts do at times find that these prosecutors who stray outside the lines have only committed harmless error, it's important to preserve all appellate issues, particularly in a closely balanced case. I've had murder convictions that we were able to overturn on appeal because of the cumulative nature of the errors by the prosecutor, including inappropriate statements made during closing arguments. So even during the government's argument, make sure to maintain your aggressive representation of your client without coming off as an obstructionist or just being petty. If the errors committed by the government during the argument rise to the level of a mistrial, make sure you state your objection for the record. You need to preserve that issue for appeal, and also ask to approach, telling the judge on the record that you have a motion to make. If the judge allows you to approach at that time, inform the court at the sidebar that you have a motion for mistrial to make and you would like to present your arguments outside the presence of the jury. If the judge declines to allow you to make the argument at that time, don't panic. Just request again to spread your argument of record after the jury is retired to deliberate. In a jury trial, my strategy is always, in making a motion for mistrial, is to ask the judge to take my motion under advisement until the verdict is returned. Obviously, if the verdict is not guilty, the motion for mistrial is moot and doesn't need to be heard. But if there is a guilty verdict, this approach will give you yet another bite at the apple, another chance to get a proper result for your client. During your closing argument, be sure also to address that the government has the opportunity to make a rebuttal argument. You want to address that before they get up and speak. Make sure that you point out that the only reason that they get to speak last is not because they have something more important to say or because what they say should be given more weight. It's because they have the burden of proof. I always tell the jury that in the event that the government raises some issue during the rebuttal argument that I have not addressed during my argument on behalf of the defendant, that justice dictates that they consider all of the evidence and determine what a fair response would be if I was given a chance to speak again after the government's rebuttal.